Hi, friends. I am here with my amazing friend, Teresa Gutierrez. Hi, Teresa. How are you?
Hi, Eva. I'm well. How about yourself?
I'm doing great. Thank you so much for joining. Not only are you a great friend of mine, but you're also a wills, trust, and probate attorney. So I'm really excited to have you. I've had several clients call me and ask me, how do I do this? How do I make sure that if something happens to me, especially with COVID, if something happens to me, that my family is protected? Families that have a house, that maybe they have another house back in their home country. So it's something that we're all talking about, right? How do we protect our loved ones?
For sure. Well, first and foremost, thank you for having me, Eva. It's such a pleasure to be here with you this afternoon. And before we get started, just a quick disclaimer. We're here providing information, some education, and anything that's discussed here today does not create an attorney-client relationship or is not meant to be taken as legal advice, right? We always caution against that. Everybody has their own unique circumstances for which they might seek unique one-on-one advice. So everything here is educational, informational. So with that said, Eva, I mean, what you said is spot on. We're living through some very difficult times with this raging and ongoing pandemic that really has people, I think, like you said, questioning, thinking about ways that they can protect themselves and their families and all of their hard-earned assets, right? Something that's always been important, but I think definitely at the forefront for people right now. So I think you mentioned home ownership. Obviously, for many people, their home is their most prized asset that they want to protect, hands down. Some people may not have a home yet, may be aspiring toward that. Others might already have a home, a primary residence, and then also have maybe commercial real estate or investment properties that they rent out. So everyone's situation is unique. But I will say, Eva, that at least in the state of California, if someone is 18 years or older, they should consider contemplating sitting down with somebody and evaluating how they might want to get at least their first estate plan set up, right? That's going to look different for everybody, for somebody that has a home, somebody that does not. But the important thing is to start the conversation, to take that first step. But I think in the first example you gave, for somebody that might have a home, I think they're definitely going to want to sit down and contemplate, sure, not only what happens at their passing or in the event of a couple or a partnership, what might happen once the second of them passes away in terms of transferring their wealth to the next generation or to whomever they want it to go to. But also, you mentioned COVID, but it's very important, Eva, in the estate planning process to also plan for our potential incapacity, right? So many people choose to do estate planning in California because they want to avoid this very expensive, lengthy process known as probate, okay, which is a means to an end. It's a way to get access essentially to loved ones' assets if they've passed on intestate, without an estate plan, usually without a trust or a will intact. That's called passing away intestate. And there's a process called probate. It's basically an estate plan that the state of California has set up for those of us that might not get around to setting up an estate plan on our own, which if we do, usually can be handled in private, without any sort of court involvement or court expenses. So that's usually what people are trying to do. But again, we also need to think about what happens if, I, Teresa, become incapacitated on a short-term basis. Maybe I'm in an accident or I become ill, and then I cannot make medical or financial decisions for myself. It's very important to create potentially some sort of health directive or advanced power of attorney that gives people that I trust, known as agents, the permission essentially to make decisions if I cannot. And this keeps us out of probate court during our lifetimes, which is really considered a probate during our lifetime, which is called a conservatorship case, right? So I have worked on numerous conservatorship cases over the years. different things trigger the need for establishing these type of cases. Sometimes it's Alzheimer's, dementia, old age. The individual never got around to making a plan. Sometimes it's, folks like ourselves, car accidents, biking accidents, accidents on the job. I've represented construction workers before, that had hundreds of pounds fall on them, be all of a sudden disabled. Maybe they come into some sort of settlement because of a lawsuit. They don't have an estate plan set up, so there's nobody to make these medical financial decisions for them during the incapacity, but then they're coming up on money through a settlement. So then they also need some sort of trust now set up for somebody to help them manage those funds. So there's all different types of needs. I think, yeah.
You touched on something very important, just so that, and I'm so glad that you're educating me on this and educating anyone who's watching this video. So estate planning is essentially planning for those situations that unforeseen situations that may come into play during our lifetime, and stipulating what decisions we want in the case of being incapacitated, or what happens if you're not able to make your own healthcare decisions. So that's part of estate planning. Did I understand you correctly?
Exactly. It's definitely twofold. Passing on our wealth once we're gone, whatever that may look like for us. And then also preserving our estate to protect ourselves during our lifetimes, right, from this expensive court process. So you could think of the planning for our incapacity as pretty much an insurance. We hope we're never going to need these directives. We hope that we're never going to fall victim to these illnesses or these circumstances. But if the unthinkable does happen, we want to be prepared, because certainly in those moments during an accident, during an illness, I would say that most folks probably do not have the capacity, the awareness, maybe because they're on medication or hospitalized, whatever the case may be, to appreciate the content of these instruments, their meaning. Right? They don't have the requisite capacity to enter into these agreements, enter into these contracts. So it could be very challenging to execute them during a moment of emergency, which then, I tell people the probate court isn't necessarily a bad thing, right? You're still going to get there. It's just a different way. It's more costly. It's public, that type of thing. It's cumbersome, but, it shouldn't be, I think, the go-to, in these situations. Hopefully not, but sometimes there's no other alternative. So, you want to link up with somebody that's going to educate you, guide you through the process, and really try and make it as easy and cost-effective as possible.
Understood. So the part of the will comes under the umbrella of estate planning.
Traditionally, yes. And I think a lot of people, when they think of estate planning, maybe they sometimes use the will interchangeably with the trust. They are two very separate instruments, and again, we're just having a very preliminary conversation here for educational information purposes, right? But I caution everybody out there, just be careful, if you're searching the internet, things like that. Those could be great resources for educational purposes, but each state is different. Each country has their own set of laws, right? So, right now for our purposes here for this conversation, we're talking California, but I think even in California, a lot of folks use will, trust interchangeably. They tend to go hand in hand, and many estate plans include both. However, I think depending on each individual specific situation that hopefully they'll discuss, with a legal representative whom they feel comfortable, is which one should be the primary planning vehicle for that person or for that couple or for that partnership or that unit, group, family. Because, the difference in essence between the two is that a will, if a will is used alone in California, it still has to be probated, meaning if the person sets up a will, yes, they've given, the court, their loved ones, those are leaving behind, the benefit of knowing whom they want their assets going to, and, you know, in what proportion, if they're divvying it up amongst various people or various entities. So the court still has the benefit of their thinking. However, the very essence behind a will, if it's used as a primary planning vehicle, is that it still has to be probated. So it doesn't get you out of the court oversight or the court fees if used alone, right? If the trust is the primary planning vehicle, which I think for most folks in California, that tends to be the preference, particularly when they are homeowners, a trust is usually highly sought after in California because it could be handled privately. In essence, it's an agreement between the person that's created it and him or herself, or, you know, in the case of, you know, couple, something like that, it's an agreement between themselves about how they want their estate, you know, managed during an incapacity, but then also leaves instructions for how the estate is to be distributed, typically at the passing of the second of them, or however else they arrange it. If there's something going to an entity or a group of people, when the first one passes, they can make arrangements for that. And then what's left, once the second one passes, will go to whomever they've indicated, right? But when the trust is the primary planning vehicle, usually speaking, if nobody's challenging the trust, at the passing, you know, of the individual or the second of them, usually it's going to be managed and handled privately by what we call successor trustees, right? People that when you've created the instrument, the trust document, you are going to sit there with your representative and contemplate and think about who you might list as successor trustee or successor trustees. Obviously, these are people, you know, that you confide in, you know, to honor your wishes and carry everything through. But, you know, once you think that through, typically those individuals that are listed will step in either in your incapacity or your passing to make sure that your estate is distributed according to plan.
Very interesting. I had no idea. So the fact that you have a will doesn't mean that you're going to state out of court.
No, a will alone in California does not mean exactly that you will 100% stay out of court. Yeah.
I am so glad we have you.
I know there's so much information, so much to learn out there. Absolutely. Yeah. There, again, it's a no one case fits all scenario, right? Everybody's going to have their unique situations. And I think, you know, so we've talked a little bit about the importance of estate planning and how it's meant to protect and preserve not just your assets, but hopefully, you know, your relationships, right? Once you pass on, because you're giving instructions about what you want versus people figuring it out. And, you know, if the property ends up in a probate proceeding, it's not so much that the appointed representative by the court at that point decides how the estate is distributed. A lot of people have that misconception too. Oh, you know, if the wife or the husband is left behind and they file the case, isn't it true that they're going to decide who gets everything? No, that's not true. What they're trying to do when they file the probate case is to be named representative of the estate. And if the court names said individuals representative of the estate, well, then what happens is once they're named representative of the estate, it's their job to essentially marshal the assets. They got to figure out what was left in the estate. They have to identify the heirs who were left behind. And then the probate court, the California system, this default estate plan, if you will, essentially has a chart. It's all set by code about who gets your estate, depending on who was left behind. So the person actually named representative by the court, the person that files the case, or sometimes there's multiple people trying to get in and be the representative of the estate, whoever's ultimately selected, no, he or she does not choose how the estate is distributed, but rather they're assisting the court in the process. And ultimately it's divided according to code, right? Was there a spouse left behind? Was there a spouse and children left behind? How many children? You know, if no spouse, no children, okay, did the person leave behind parents, siblings, nieces, nephews? It goes down. So you could see how leaving it up to probate might frustrate your intentions if there's certain individuals that you would not want your estate to go to, right? And by setting up a trust, you can do that. You can specifically disinherit folks, right? You can have your beneficiaries, and then you can have backup beneficiaries. I mean, there's a lot of things that you can do. So there's that. But I would say, in addition to planning for what happens, passing your wealth on to the next generation, let's say, or protecting yourself from court proceedings in the event of incapacity. A lot of people that have minor children also like to take it a step further and do some sort of planning in case, they ever pass away while their children are minors. They like to list guardian nominations, guardianship nominations. And that's very important. I work on a lot of guardianship cases in court too. And in essence, a guardianship is a custody matter over a child that's not yours, right? So I could go into court and seek custody over like a niece, a nephew, the child of a family friend, acquaintance, whatever the case may be. In essence, it's a guardianship is custody over a child that's not yours. And a lot of the scenarios under which this comes up is if a person is incapacitated and cannot take care of the children or their child for a short-term or long-term basis due to a disability, incarceration, deportation, or death, right? Those are the scenarios I see them usually triggered in. And so what happens is if you have your guardianship nomination set up and somebody has to go in and petition the court to be legal guardian, okay, or to have custody of your child or your children, if they attach the guardianship nomination to the petition, things are probably going to go a lot more smoothly for them, and your wishes are more likely to be honored than if you don't have a guardianship nomination. But similar to the probate process, if you haven't listed your successor trustees or in a will, your executors, the court's going to have more say of who that is. And a guardianship, it's very similar. If you haven't in advance listed your guardianship nominations, it's really going to rest solely on the court who's going to serve as guardian. But if the court has the benefit of your thinking through these nominations, the individual or individuals that you've listed are going to be more likely to have success in getting custody over your child versus maybe an estranged family member or somebody that you would never, dream of naming, right? So I have cases that are contested too, where multiple people are fighting to be guardians of children, some that maybe never had a relationship with a child before the parent or the parent's deceased. So it can create a lot of dicey situations, that people are trying to avoid. So in essence, estate planning is really, trying to give yourself peace of mind, your loved ones peace of mind. It really is a gift, to yourself and those you're leaving behind. Really, that's what this is.
Wow. There's so much and so scary. I'm just thinking as you were mentioning all the potential scenarios, I'm thinking, oh my goodness, I have to talk to you privately.
Of course. That's what we're here for.
But this is wonderful. I'm sure that we're going to have you back. I'm sure we're going to get a ton of questions. And Teresa, you do speak Spanish, right?
I do. I am fully bilingual in spoken and written Spanish, 100%.
Bilingual and bicultural.
Absolutely.
Thank you so much for joining us. We're going to have you back. We're looking forward to seeing you again.
Yeah, we will stay tuned. Thank you for having us, Eva. Appreciate it.
Thank you, Teresa.
Everybody, for tuning in. All
Bye.
right. Sounds good. Bye.